Throughout the previous modules, we explored how real estate law in Arizona establishes the foundation for obtaining, maintaining, and regulating a professional license. We examined the role of the Arizona Department of Real Estate, ADRE, the Commissioner's authority, and the importance of license status in determining who can engage in lawful real estate practice. This section builds upon those lessons by defining what it means to be a licensee and identifying the specific activities that a licensed individual is authorized to perform under Arizona law. These concepts are essential because they directly relate to consumer protection, professional conduct, and compliance with the statutory requirements established under Arizona Revised Statutes, ARS, Title 32, Chapter 20, and the Arizona Administrative Code, AAC, Title 4, Chapter 28. A licensee in Arizona is any person who holds a valid license issued by the Department of Real Estate, authorizing them to engage in activities that require licensure. This includes salespersons, associate brokers, designated brokers, and certain specialized license types, such as cemetery salespersons, cemetery brokers, and membership camping brokers or salespersons under ARS Section 32-2101-50. A real estate licensee is defined as any person, partnership, limited liability company, or corporation who is licensed under the provisions of the real estate statutes to perform acts of brokerage for compensation or with the intent to receive compensation. The scope of a licensee's activities is broad but carefully regulated to ensure compliance and accountability. According to ARS Section 32-2101, open parenthesis, 48 close parenthesis, engaging in real estate activity includes performing acts such as listing, selling, purchasing, renting, leasing, managing, exchanging, or negotiating the sale or lease of real property for others and for compensation. It also includes assisting in locating property for buyers, advertising or holding oneself out as being able to perform these services, or collecting rent and handling trust monies for property owners. Essentially, if a person is acting for another and expects to receive payment, they are engaging in activity that requires a real estate license. For example, consider a person who regularly helps friends buy and sell homes and collects finder's fees for each referral. Even if they do not think of themselves as an agent, their actions fall under the definition of real estate activity under ARS Section 32-2101, open parenthesis, 48 close parenthesis, because they are performing services for others for compensation. Without a license, such conduct would violate ARS Section 32-2122, which prohibits any person from engaging in real estate business without a valid license. Similarly, if a property manager collects rent on behalf of an owner or negotiates lease terms, that person must hold a real estate license unless exempt under ARS Section 32-2121A, which outlines activities not requiring licensure, such as managing one's own property or working as a regular employee of a property owner. The law draws a clear line between activities that require licensure and those that do not. A license is required when a person acts on behalf of another and receives or expects to receive compensation for those services. However, activities that are administrative or purely clerical in nature, such as scheduling showings, typing contracts, or providing general office support, do not require a license as long as no negotiation, representation, or compensation-based service occurs. The Commissioner's Rules R4-28-3, 01 through R4-28-303 further clarify these boundaries by regulating advertising, transaction documentation, and supervision, ensuring that licensed activity remains under the direct oversight of a designated broker. Real estate salespersons and brokers each have distinct scopes of authority. A salesperson must always work under the supervision of an employing broker and cannot operate independently. The broker assumes full legal responsibility for all acts performed by the salesperson, as outlined in ARS Section 32-2153A7. The broker, in turn, may act independently or manage a brokerage, supervising all salespersons and associate brokers employed under their license. Brokers must maintain control of all trust accounts, contracts, and advertising per R4-28-1103A, ensuring that every transaction complies with statutory and ethical standards. For instance, when a salesperson prepares a listing agreement, the broker must review and approve it to ensure accuracy, legality, and compliance with ADRE requirements before it is presented to a client. The authority to act as a licensee also includes fiduciary obligations to clients. These duties, loyalty, disclosure, confidentiality, obedience, and reasonable care, are established under ARS Section 32-2153A3 and R4-28-1101B, which require licensees to protect and promote the interests of their clients while treating all parties to the transaction fairly. Violating these fiduciary duties may result in disciplinary action, including suspension or revocation of the license. For example, if a broker fails to disclose material information about a property's condition, or a salesperson misrepresents an offer to a client, they could be found in violation of the commissioner's rules and subject to sanctions. To illustrate, imagine a licensed agent named Sarah, who represents a buyer in the purchase of a home. Her authorized activities include showing properties, drafting the purchase contract, submitting offers, negotiating terms, and coordinating inspections, all within the scope of her license. However, Sarah cannot act as a dual agent or collect payment from anyone other than her employing broker without full disclosure and written consent, as required by R4-28-1102 and ARS Section 32-2155A. This reinforces the structure of accountability and ensures ethical conduct in every transaction. The definition of a licensee also extends to the responsibility of professional behavior beyond active transactions. A licensee is always bound by the standards of honesty, truthfulness, and fair dealing described in ARS Section 32-2153A. Even actions outside of direct sales activity, such as advertising, marketing, or social media promotion, must comply with the Commissioner's rules. Any form of communication that gives the public the impression that a person is licensed must be accurate, transparent, and approved by the employing broker review summary. In this section, we learn that a licensee is any person authorized by the Arizona Department of Real Estate to engage in real estate activities as defined under ARS Section 32-2101, open parenthesis, 50 close parenthesis. Licensed activities include listing, selling, leasing, renting, or negotiating real property for another and for compensation. Only individuals with an active real estate license and an affiliation with an employing broker may legally perform these activities. Administrative or clerical work does not require licensure, but any act involving negotiation, representation, or compensation does. Brokers are responsible for supervising all licensees under their control, and every licensee is expected to act with integrity and comply with all statutory and ethical obligations established under Title 32 and the Commissioner's Rules discussion. Why is it important to clearly define who qualifies as a licensee under Arizona law? Answer: it ensures that only qualified, supervised professionals engage in real estate transactions, protecting the public and maintaining industry integrity. What activities require a real estate license under ARS Section 32-2148? Answer: listing, selling, purchasing, leasing, or negotiating real estate transactions for others in exchange for compensation. Can a person perform administrative work in a real estate office without a license? Answer: yes, as long as the tasks are purely clerical and do not involve negotiations, representation, or compensation based services. Who bears responsibility for the actions of a salesperson under Arizona law? Answer: the employing broker, as defined in ARS Section 322153A7, who must supervise and ensure compliance with all real estate laws. What could happen if an unlicensed person engages in real estate activity for compensation? Answer: they may face civil penalties, cease and desist orders, or criminal prosecution under ARS Section 32-2122. Closing remarks. Understanding what it means to be a licensee and the scope of authorized activities is essential for maintaining professional compliance and public trust in Arizona's real estate industry. Every licensed individual must recognize the limits of their authority, the supervision required by law, and the fiduciary duties owed to their clients. The definition of a licensee is more than a legal title. It represents a standard of professionalism, integrity, and accountability that protects both consumers and the reputation of the real estate profession as a whole.